School of Education, and I am very pleased on behalf of the school and Dean Terry Mason to welcome you to the Martha McCarthy Education Law and Policy Institute. The institute was launched in 2013, so this is the fourth institute actually, and gets better each time. This institute is very important to the School of Education because it fits very well into our mission to provide cutting-edge research and thinking to benefit school leaders and policymakers. The Institute provides some incredible resources, very practical resources that can benefit you in terms of your own setting and your work in the important area of education. So, as I said, this year's agenda is no different. It's packed with all kinds of interesting and very, very relevant topics. Speaking earlier to one of our graduate students who's a principal who said, last year he went back to his superintendent and said, well, the Institute is on this topic, and the superintendent said, it is? Why are you taking on that topic? It turns out to be transgender issues. So sometimes we even beat policymakers to the punch in this. Let me say a little bit about the namesake for this institute. Martha McCarthy is the Presidential Professor of Educational Leadership at Loyola Marymount University and Chancellor's Professor at IU. Martha was on the faculty for over 30 years here, served not only as a faculty member, but Chair of Educational Leadership and Policy Studies, Associate Dean Faculties, Founding Director of the Indiana Education Policy Center, and has received the highest awards both in Indiana and across the country in terms of her research. And I know that there are many people, many administrators in this state who not only speak highly of Martha, but talk about how Martha was accessible to them in terms of some very, very difficult times when they were trying to make some difficult decisions. Martha has mentored faculty and countless administrators in Indiana and now in California. We bring her back so she can dance here, by the way. It's like having a family member come back when Martha's here. So I'd like you to join me in thanking Martha for the legacy that she's provided by her life, her experience, and have her stand. This is the plug part of my speech. If you find the Institute valuable, which I'm sure you will, and want to contribute, it is possible to donate money to the Institute. Joe Cantor, who is someplace, right there, waving his arm. Joe Cantor is the Director of Development for the School of Education. Joe will be more than glad to tell you how to do that. You can do it through the Development Office or through the IU Foundation. We encourage you to contribute to this institute, to its growth and enrichment as well. Finally, I just want to say a few words of thanks to several people. First of all, to Suzanne Eckes and Janet Decker, two faculty members in educational leadership and policy studies, whose incredibly tireless efforts make this possible in terms of their own expertise. Many of you know them in classes or consulting with them in your school district, but I appreciate all the work that both of them have done to bring this about. I also want to thank Colleen Chestnut, who's sitting way in the back of the room, who provided much of the logistic support. Colleen has done this for, 3-4 years? 30 years at least, something like this. So she has this down pretty well. Okay. So the logistics of this are certainly credit to her. The smooth running is credit to her, and we appreciate it, colleague. While I won't try and will no doubt make mistakes by mentioning all their names, there are numerous students and faculty who've also been involved in this. So as you see them today doing different kinds of jobs, please express your appreciation to them as well. I also want to thank the experts who have joined us for this institute and who are providing their expertise. I think you will find all of them exceptionally well-versed, knowledgeable, and able to apply the sorts of things they're saying to individual situations as well. And then finally, to all of you who have exhibited incredibly good sense by registering and attending this conference, we welcome you, and I know that you will have a fantastic experience. Have a great day.
The Academy is a nonprofit organization that helps at-risk students who are on the verge of dropping out of high school stay in school. Prior to joining this organization, Teresa was an assistant principal with the Indianapolis Public School System. And then at the end of the table is one of our panelists who we look forward to seeing year after year. That's Seamus Boyce. Seamus is a partner at the Indianapolis law firm Church, Tittle, and Antrim. He represents schools and educational entities. Seamus has received the Martin Hubble Attorney Rating of AB Preeminent, which indicates the highest level of professional excellence. But what I really value about Seamus is that he has this amazing Twitter feed. It's at School Counsel, and it's an excellent source of relevant school law information. He is great about providing me with what's happening at the cutting edge. So I want to go ahead and get started, and I will just start with the topic that I'm sure so many of you are aware of. If you're following any kind of events in education, you're well aware of the controversial issues surrounding transgender students. So I wanted to start with our practicing attorneys on the panel, John and Seamus. If you could just explain what's been happening.
You know, we talked about this issue last year. A good friend of mine who was in the audience teaches here in Bloomington, and he was all excited because we said, you know, the Department of Education and the Department of Justice are going to take the position that you need to treat students' gender identity as their sex for purposes of Title IX. We predicted that that was the position that they were going to take. And if you deal with these entities every day like we do, that was not a surprising prediction. For him, though, out in the field, it was very surprising. And so on May 13th, one of the big recent developments, the Department of Justice and the Department of Education Office for Civil Rights jointly issued guidance that basically said you need to treat transgender students consistent with their gender identity. And the guidance covers a number of areas, but that's the basic principle. Obviously, the one that's gotten the most attention is use of bathrooms and locker room facilities, but the guidance also covers using the names and pronouns that students want, student records. And this has been very, very controversial nationwide. North Carolina passed legislation directly contrary to this guidance. There's a big dispute with the Department of Justice and the Department of Education over that. More than 10 states have sued the federal government over this. And so it is very much a hot topic in the news, and people in schools are definitely on the front line.
I'm happy to be back. I think I enjoy this audience. It's a little bit unique from my typical professional development audience where I'm typically presenting to only school administrators. So I think this has a wide variety of perspectives. If you recall last year, I was on the transgender panel. And we're talking and kind of a lot of the hot topics that came to the forefront this past year. I think we discussed that we were already kind of dealing with them, and we thought they were just going to get more prevalent. Oh boy, have they! I think if you attended last year, you might recall that I polled the audience via text message to tell me what you would have done in a particular scenario. And guess what? That particular scenario actually played out in a very public dispute between a Chicago area school district and the Office for Civil Rights. So I'm going to take this opportunity to do the same thing I did last year, to see if your answers have changed, because I took a quick look at the survey results from last year. So I just posted my cell phone number on my Twitter feed, so you're welcome to look at it. I'm going to tell you right now what it is too. It's 317-345-2459. That's 317-345-2459. And the poll that I want you to respond to me, and I'll take a look after I'm done with these remarks, is would you have entered into that agreement that Chicago area school district entered into? Because essentially that was the same question I asked you last year, just in a hypothetical. So take a look at that. So I think John really covered nicely the highlights of that Dear Colleague letter, the guidance material that received so much attention in the last month. A short story that I was actually presenting to the Indiana Association of School Business Officials when the letter came out on transgender. So I was in the middle of my presentation on transgender when they actually released the letter. So that was fun. So I think the two pieces that I wanted to inform you of kind of substantive developments in substantive areas is that Chicago settlement agreement with the OCR, and then also first the Fourth Circuit Court of Appeals, GG versus Gloucester, has probably received the most attention of any Court of Appeals case that I can remember in school law for a long time. And in short, transgender male student was actually using the male restroom. School board then adopted a policy requiring the use of a gender-neutral bathroom instead of the male restroom. Lawsuit ensued, lots of different people involved. The district court judge ruled in favor of the school, saying that there was no Title IX claim. And appealed. There was a lot of criticism of that judge's opinion because it was super conservative, and people realized that. And so the Fourth Circuit Court of Appeals overturned that particular part of the decision. And what has received a lot of notoriety is that one of the rationale for that decision was the United States Department of Education guidance was given great deference. And that was a big part of the analysis of the Court of Appeals, is that the Department of Education guidance was given deference. Most recently, this is still ongoing, but the school asked for what's called an en banc appeal, which is basically all the judges in the Court of Appeals here, and that was denied. There was a very strong dissent in that denial, asking the United States Supreme Court to hear the case. I think that the general consensus is it's unlikely that the Supreme Court is going to take it on, primarily because the Supreme Court likes to see what's called a circuit split. They'd like to see a disagreement between the different circuits. So we'll see what happens, but that's certainly the court, at least one court. If you're in Virginia, guess what? North Carolina gets all this attention for their legislation. Guess who's in the Fourth Circuit? North Carolina. So if you're in that jurisdiction, you certainly have some case law that you're going to have to follow. I think real briefly on that Chicago, it's called the 211 Palatine-Schaumburg School District Settlement Agreement with the OCR, transgender female, and it's that scenario of the student wanting complete access to the communal undress female locker room. And lots of back and forth. I think why it got so much attention is because that district probably pushed back against OCR, at least publicly, the most that we've seen. It's certainly something that got attention. And so there was kind of a little bit of a perception standoff that was the OCR, was the Department of Education really going to go after the enforcement process and revoke federal funds, which is their ultimate, their ultimate stick. Didn't get there. The school district had very public meetings with long testimony from people in the community, and they adopted that resolution agreement 5-2. The resolution agreement was pretty interesting. I think just a few highlights from it. One, the OCR and the school district compromised and came up with a solution of having basically privacy areas, privacy curtains within the female communal undress locker room, which were available to everyone and could not be forced upon everyone. Another piece was that the school district had to create, essentially I look at it as a kind of a team for that student, that transgender student, to address their concerns and issues. And then finally a resolution of what the policy was going to say. Interestingly, the OCR had been pushing what people were calling the Arcadia settlement agreement, which had a lot of stuff in it. And one of those items was the school district had to include a kind of a laundry list of areas describing what they were not going to discriminate against, I think, transgender, sexual identity, sexual orientation. The settlement agreement with 211, the only thing that is in that policy, that stipulated policy, is the word sex. So in their policy that the OCR and the district agreed upon, there's no mention of transgender or sexual orientation or sexual identity, gender identity, which I found was very, very interesting. So I'll stop there.
With this ever-evolving area of law and people with differing opinions, how in the world do you advise your clients on this? What are you telling school district clients?
Well, what I tell school district clients is that the best thing to do is to follow the guidance from the Department of Justice and OCR and to try to find good ways to keep students and parents who are bothered by that to accommodate their interests in privacy. And the reason that I do that, there's sort of three reasons. I think for the short term, this is going to be in turmoil and there's going to be litigation. And if somebody wants to litigate, hey, I'm a litigator, I'll defend your right not to follow that guidance, but I think in the long run, that's short-sighted. One, you look at the Fourth Circuit decision. The Fourth Circuit is one of the most conservative court of appeals in the country, and it has upheld the department's position. And so I think in the long run, there are going to be court decisions probably coming out both ways on this because of all these lawsuits, but in the long run, I think that view will prevail. I also think that view will prevail because of sort of what causes, in my view, the difference between the dissenting opinions and the majority opinions on this. And that is sort of a sense of, and this is a little difficult for me because I'm Catholic, I was raised Catholic, but the Catholic Church teaching is contrary to this, but the sense of the judges who upheld the department's position that this is a real lived experience of these students. That when they are transgender students, that is, for all intents and purposes, the sex that they are experiencing in their life. And so because of that, I think that's part of why the courts will all ultimately get to that position. Could be wrong, but I think that's where it's headed. And then the third reason that I counsel school districts to do this is because transgender students are very much an at-risk population. If you look at the rates at which they're bullied, harassed, are harmed by others, are harmed by themselves, at risk for suicide. And so I think we have an obligation to protect those students. And because of that, I think the claims of those students and the Department of Education, the Department of Justice, if they sue you, are relatively stronger than the claims of the other people who still may threaten to sue you, on privacy grounds if you follow the Department of Education. So it's going to be a controversial area. And there's no easy answers. And so what I tell districts is that you need to pick your battle, and from my perspective, you're better off on this side of this controversial issue now, because I think that's that's definitely where the federal government is. I think the courts will eventually get there, and I think it's the best thing for your students.
I piggyback off what John said. I think that obviously we've been working through this issue for years now. I think the guidance has obviously brought a lot more attention to the issue and some of the court cases in the Chicago case. So I think a lot of the kind of no-brainers and the practical pieces have already been in motion. It's gotten a lot more scrutiny, and some of it's welcome and some of it's like, well, we're already kind of doing this. It's just made it even more complicated. So that's difficult to work through sometimes. But if I wanted to, I could probably this summer only do professional development on this topic. It's by far the hottest topic, and everybody's hungry for information. So at the end of the day, my obligation is the client to advise them of what the legal standards are and to look at the risk benefit of different things. So I think the default is you have to follow the guidance, because if you do not follow the guidance, then you could be at risk of being a target for investigation, inquiry, litigation, and certainly if the Seventh Circuit adopts that standard, which it hasn't directly done, but there are some cases out there that have insinuated that the DOE guidance needs to be given deference, kind of similar to what the Gloucester case said. So that's the default. But at the same time, I'm practical to know that it's not as simple as that guidance letter sets forth. I mean, it is more complicated. I think everyone recognizes that. And if they don't, then they're living in a vacuum. So I think that there are, at the end of the day, are my first consideration. Well, what's your policy currently say? And your step number one is to ensure that your policy is compliant. That you've got all the processes in place, that you've got all the required protected classes in place. And then also people miss that it's not just Title IX. I mean, we've got potential state law that's not on the books, but it's going to be continue to be discussed until there's something. I don't think that debate will ever end. And then what is missed a lot of the time is that there's very well maybe you have a local ordinance that does preclude discrimination on the basis of transgender or gender identity. And many of those ordinances have enforcement mechanisms. For example, Indianapolis, they have basically their own internal civil rights commission, which could look at something and say, well, that's in violation of our non-discrimination ordinance and enforce it. So you need to be aware that it's just not following the guidance that you have to address. But I think what John emphasizes that I agree with most is that what resonates with the administrators and the school employees that I provide professional development to is that when I do it, I have a slide where I'll pull up and say, here's all the legal standard, but at the end of the day, this is about these people. And I will pull up and I will have real life examples of transgender students. And they find, and a lot of times they see all these tricky, sticky issues and complicated political issues, but they know that this is about their kids, and particularly the building administrators realize that these are their kids. So they're going to do what they can to make sure that they feel welcome, not discriminated against, part of their community. But hopefully on a case-by-case basis, kind of understanding what the family and what the student wants in that scenario.
Before moving on to the next topic, do any of the other panelists want to speak about this issue?
I'd like to say one other thing about that is just because there's agreement here, I have a good colleague who is fighting the officers in this behalf of the district. And so, I think what you're hearing here is very sound, but I don't want to make it seem like it's universal agreement out there on this. There are people really pushing back. As I said, there's 10 lawsuits more than 10 lawsuits challenging. And so it's going to be controversial, whatever you do. You just have to make your decision about the right to see and children.
One thing I did not mention about the Chicago area case was they had the resolution agreement, and many people thought, well, that was going to go away. But at the actual testimony before the board took action, there was somebody speaking on behalf of a parent group, which essentially said, we're going to sue you if you enter this agreement. And guess what they did? So there's a group of 65 plus students that have filed suit against the district, the DOE, and others, challenging the authority to enter that agreement and basically challenging the legal protection of those students. They are being supported by an organization, I think it's called the Alliance Defending Freedom Group, which is very much providing the legal horsepower to support that issue. So that is potentially going to be a Seventh Circuit case that we're going to have to follow in our jurisdiction.
I just wanted to raise questions that you over and against on occasion. What triumphs here, the language of Title IX and regulations, or the guidance put out by the Department of Education? And again, from the paralegal standpoint, I think that remains to be seen, as both sides try to get respected. So I think we're in the very early stages of something that's going to play out over a long period of time.
I do think that everything is very, when you're in a courtroom, I guess, and when you're reading everything on a piece of paper, it sounds very abstract. So, and I feel a little intimidated being surrounded by lawyers, have my little education degree. But I will say this, those of us who are, and I think you both alluded to it, we are with these children, and we understand that there is real pain involved in some of these situations with these kids. And so, although we also understand too, because these are all our kids, right? That there are kids who really have a very firm belief about how they have been brought up and what they have been taught is right and what they think should be happening, and their parents are in there too. So there's laws, and that we know that we need to come down on the side that is going to be right, but that right becomes amorphous sometimes. For me, my thought is always about not limiting the rights of people who tend to have their rights limited the most. So whenever I'm looking at a decision like that, that's my thought. I don't want to limit people's rights, because I've had my rights limited. It's not fun. So although there's a lot of legal stuff that we definitely have to consider, I feel like I could withstand the lawsuit from the people who are saying, you know, that we're religious freedom people. I love how they always put freedom into the title of something that seems to be impinging upon the freedoms of another group. Very interesting. But I feel like that I would rather be, when history turns around and looks back at me, on the side of preserving the rights of someone who had been in a position where they were in a position where they didn't have any power. That's just my thought on it personally.
I just want to follow up on what Teresa and Charlie both said with sort of a very practical thing for everybody here to think about as a voter. So Charlie pointed out that the Fourth Circuit decision rests on the fact that the term sex in Title IX, according to the Fourth Circuit, is ambiguous. And the Obama administration is interpreting sex in a way that Teresa favors and I favor, that includes gender identity, you know, as part of sex. That gender identity is a real thing, and we're going to treat a transgender person's gender identity as their sex. Depending on who's elected president and who's running the Department of Education, that interpretation of the term sex could be changed, consistent with the case law we have today. And so, you know, it's interesting, these arcane legal disputes and these very grassroots things that you deal with in schools every day. Actually, it really makes a difference what happens in the upcoming election on issues.
Here's another very real thing for the people that are in Indiana to be aware of. Who's familiar with the IHSAA position on this topic? There's some exceptions to it, but essentially the default position is you have to have a sex change to participate in the gender non-birth gender. And there is so I think kind of from a practical reality, I share that with people, and I say it very well may be that when there is a dispute about this in the near future, it will involve that. Now it will involve the school as well, because the school is agreeing to follow the policy, and maybe the school is going to be kind of collateral damage in that dispute. But just think about that. How is that position going to mesh with the U.S. DOE position? Very interesting.
Seamus, a follow-up on that. As Janet indicated, we were at Disney, so I was living off of my BlackBerry and headlines. But I think it was in Alaska someplace where a transgender student won some kind of state athletics championship. It was biologically, chromosomally still male, defeated a bunch of female students. I wonder where those questions are going to go. What if you get a petite person, I don't really care what gender, but decides to want to play football and gets injured in the whole context of it? I just wonder, and again, I teach for a living, or I try to teach. I like to tell them, you blow in, you blow off, you blow out. You come in, you give me a talk, you raise tough questions, you say, have a nice life, I'm leaving, you figure it out. So I just wonder how much thought we've kind of given down the line. Again, we can't be prescient. We can't know what's going to happen 12 years from now. But again, as somebody who does teach law for a living and has done for the last 25 years, I try to raise the question, can we think some of these things further, particularly with issues of student safety, as in some places. I learned a long time ago that I thought religion was real important in Texas. There's an even bigger religion called high school football. So, and I think Indiana's that way with basketball. I taught at the University of Kentucky, so I understand basketball and that. Again, just raising the questions for safety on both sides of the issues, and I don't think we can really know what's going to happen. I just throw it out there in the mix.
One note is that the guidance from the Department of Justice and the Department of Education, well, I think Seamus is right, they would probably consider the IHSA thing to conflict with it. It does have a carve-out for issues of safety, medical issues, competitive fairness. We've all seen the whole controversy in the Olympics. Those of you who are old enough, rather, you remember the East German Olympic teams and doping and questions of hormone therapy and all that. And so the Department of Education and the Department of Justice do have sort of an acknowledgement that athletics and competitive fairness and keeping people state and contact sports and all of that is fair. But on the other hand, they don't want people to have sort of universal policies that, for example, keep maybe a fourth grade transgender girl from playing on the girls' basketball team where it's, largely non-competitive elementary school basketball. I think their practical interpretation of that is, no harm, no foul, so to speak. So there is a carve-out in the guidance, but I think athletics is maybe one of the harder issues we see.
And fourth grade is a little bit easier than 12th grade.
Yes.
Well, very good. I'm sure we'll be talking about this issue throughout the entire institute today. I know we have a roundtable that will focus on this issue, and we also will hopefully have some time at the end of the panel for audience questions as well. But let's go ahead and move on to another hot topic, and this is specific to Indiana, but relates elsewhere. In Indiana, we've had a lot of local news attention on a few incidents where school administrators have known about teachers or other school employees sexually abusing students and failed to report that abuse to outside authorities, such as the Department of Child Services, in a timely manner. So first, I'm going to turn to Seamus. Could you please summarize what's happened recently, and then explain how you advise your clients about reporting when the accused is an employee?
So if I wasn't spending all my time on transgender professional development, I could also just be spending all my time on proper and appropriate abuse and neglect reporting professional development. So I think, in short, I think everybody that lives in Indiana has, whether you like it or not, heard about different examples of bad situations, whether the employee was directly involved in the suspected or alleged abuse or neglect, or there was an improper disclosure or improper lack of disclosure made, and just lots of examples. And for a while there, it was just like, who's going to be next? So I think it's a combination of super sensitivity to it and then real problems. So that's the context for it. So most of my time is to set the context, make sure that people are taking it seriously. Which, if they didn't have full attention of this topic, this time last year, they certainly do now. So it is not just me saying you need to know about it. I'm getting requested to make sure that they're doing it right. So similar to almost any other topic, my first step with an individual school is to say, what does your policy say? Because many times I'll ask that question when they're involved in a situation and they say, well, I haven't checked the policy. So you want to make sure that you know what the policy is, and then we'll say, well, is that a good policy, or should you do something different? And you want to do what you think is appropriate, number one, to protect the people that are in your community, kids and adults, and keep them out of any harm. But then beyond that, I think nobody wants for anyone to be out of compliance with the criminal standard. So I have tried to succinctly, when I do this kind of presentation, it's about an hour, 2 hours of a variety of issues, and then we go through hypotheticals and a lot of difficult scenarios with moving parts. But I always tell them that the most important slide, when I get to it in the PowerPoint slide, is the summary of the criminal standard for abuse and neglect reporting. And that is as follows. The current standard in Indiana, any school employee who has reason to believe that the child is the victim of abuse or neglect, regardless of who the suspect is, whether it's a parent, a third party, a school employee, they have an immediate obligation to report that belief to that child's building principal or the building principal's designee. They don't have the immediate obligation to kind of think about it and check the credibility and consider the source. No. When that light bulb goes off in their head, they should have the itch to make sure that gets properly reported. And that their obligation does not end with them reporting it to that individual. If they have reason to believe that it wasn't properly reported to authorities, they have the obligation to directly report it. But the next step of the analysis is, once the report has been made to the appropriate person, the building level administrator, then that person has an immediate obligation to forward the report. They do not have the immediate obligation to do their due diligence, check credibility, do their internal investigation, make sure that everybody's statements line up. No, they have an immediate obligation to forward the report to the Department of Child Services or local law enforcement. I strongly suggest that in every situation that you at least make a DCS hotline report. And in the perfect scenario, that person that comes to the building level administrator should stay in the room, and the person should get on speakerphone the DCS hotline operator, and the person that actually had the belief that, hey, it was my observation, or I first got the information, they should relay the information so we don't have triple, quadruple hearsay. That is not going to work out in every scenario, but I think that's the default if you can make that happen. There has been some recent changes that we always suggested that report get made immediately. It was made absolutely clear in the last round of the legislative session that word immediately was included for the obligation to forward the report. So that is, in a nutshell, the criminal legal standard. So if you don't follow that, I think it's a Class B misdemeanor, up to 6 months in jail, and hefty fine. Nobody wants to be it. Nobody wants to be the headline, but that's a secondary concern. We want to protect kids. So regardless of who the suspect is, a third party, family member, adult in the building, we want to protect those kids. I will tell you, one of the most complicated part of this is the dilemma that the best intentioned, particularly building level administrator, knows that with all the scrutiny that this has received, the amount of reports has just skyrocketed. And so the result of that is DCS hotline just being inundated, and they absolutely cannot handle the volume. The hotline can't handle the volume, the screeners can't handle the volume, the caseworkers can't handle the volume, and we're seeing it play out in a whole lot of scenarios. And so the person that makes the report says, "Here's what we know," and then they get the insinuation from the DCS hotline worker that, "Hey, we got a lot of questions here. Is that all the information that you have?" And kind of insinuating that we're going to screen this out unless you give us more information. So that administrator's in the dilemma of knowing that if they don't get more credible information or more detailed information, that they could actually be doing harm to the investigation because it could get screened out. But I say, you have the obligation, you have a criminal obligation to make a report. I think you can say, you've been advised that you need to make the report. You can take their questions and you can try to gather more information and follow up, but you got to make the report immediately, and you can't do your first investigation before you make the report.
Teresa, what is happening in schools? What are you seeing?
Well, I may or may not be part of the school system where this may or may not have happened recently. And as a result, and those of us who work in schools know that when something big happens, always there's now all this attention on it, and so we go back and we all have to be retrained, and there's new policies put in place and things like that happen. I joke about certain things being Principal 101. Like, when you go to your first class, this is one of the things they tell you. We, in Teacher 101, I believe, we're taught, we are mandatory reporters. If anything happens, you have an obligation to tell. And whenever a kid comes to me and says, "Can I talk to you? Can I tell you something?" But you have to promise you can't tell anybody else. My response is always no. I can't promise that. I tell them, I will listen to you, but I'm going to tell you up front. These are the things I have to report. So we all are aware of that. Unfortunately, I think what oftentimes gets bogged down are the procedures that are put in place by the organization. And in the organization I work for, my school is a part of Indianapolis Public Schools. We are affiliated with the Simon Youth Foundation, but we are Indianapolis Public Schools. So I am an administrator for IPS. We have a procedure, and there's a procedure that has been in place since I became an administrator 10 years ago. Unfortunately, I think what happens sometimes is that when there's transitions in leadership and transitions leadership of the whole district and transitions to leaderships of buildings, reinforcing those things kind of gets lost, reinforcing what the actual policy and procedures are kind of gets lost. It's one of those things that needs to be basically every year talked about. When I have a staff meeting every year, that's one of the things I address with my staff. This is what our procedure is. As a result of what's happening recently in IPS, we now have all of the administrators have, we were in a meeting where an attorney came to us, one of our attorneys, because we obviously retain a whole firm. And so one of the attorneys came and spoke with us and outlined kind of what our procedure and policies are going to be. And unfortunately, it does end up making multiple reports to CPS in order to make sure that everybody is reporting. So now there are, if a teacher comes to me and says that something has occurred, I, of course, will make a report, but then the teacher, they're also recommending or suggesting that they file one as well, which my thing is I bring them into my office and have it and do exactly what you were just saying, so that we can sign on the same piece of paper. But basically, everybody who is aware is now charged with the responsibility of making a report. So it can overburden the system because it is not our responsibility to investigate. And that's one of the things that we know. We don't investigate. If we have a suspicion, then I may investigate if, so-and-so is mad because so-and-so talked about so-and-so on Instagram the other night, and so now there's about to be this fight, blah, blah, blah. Well, that's an investigation. We'll get to the bottom of that. We'll figure out why you're mad. We'll resolve that. Well, that's okay. I don't investigate when it comes to a child being hurt. I just report it. I don't investigate. That's not my job. My job is to protect kids. So it is unfortunate that now, because of all this scrutiny, I do see that the system is being bogged down, and I am concerned that students who really do need help may not get it in a timely fashion because, right now, our issue was allegations about sexual relationships. There are also kids in homes that are being hurt, and this was a staff member, sexual allegations against a staff member. So that's something happening in our schools. That's a huge problem. But there are kids in homes being hurt that, their problems are now in a queue with all these other suspicions that we have because there's now this high level of scrutiny. So it's kind of a catch-22. We, in our district, have reiterated what our policies are. We've actually revamped what our policies are. It's a little bit more complex now. We do involve our school police because we have a police force with arrest powers in our district. So we do involve our school police now, whereas before our policy was just to inform DCS. There's a form that we fill out. There's a phone call you make. You write down the name of the person you reported to. You write down all allegations. Everybody signed it, and then it went to a certain person, a clearinghouse in IPS, and then DCS investigated however they investigated. If it was a staff member, then we were to call HR. That was the old policy. The new policy is that and I don't even have it memorized. I have a piece of paper in my office with it on it because there's several steps and checklists, and it's a lot. And I have to refer to it if there's a report. But I know what the number one thing is I'm going to call and make a report to TCS.
It's interesting how a few, cases that get popularized and change the implications for administrators, for attorneys, for DCS. It's interesting. Thank you for that. I want to move on to U.S. Supreme Court cases. It's always a fascinating topic that have happened in the past year. So I want to ask Charlie, what's the status of religious freedom in light of the Little Sisters of the Poor case and other recent litigation? And also, could you describe some of those decisions with the Little Sisters case and explain the implications for religious freedom?
I'll try.
Okay.
Thanks for the question. Just a kind of an introductory comment to this case, should be very well, and perhaps John's and the one I'll talk about with Time Friedrichs. I think that the unknown is the replacement for Justice Scalia. Right now, we've seen a series of lower court cases. I think we'll have a couple more coming down. I don't know whether John agreed. We haven't talked, but I have a feeling Fisher's going to wind up before as well. And given Scalia's death, I've seen a great deal of commentary and two kind of points of view emerge. On the one hand, people are somewhat thankful, if that's the right word, that it avoided the courts going to another series of somewhat bitter 5-4 decisions. I think if Scalia were alive, the decision in Zubik would have been a bit different. Have a lengthy piece coming out in the Education Law Reporter, for those who are familiar with it, on Friedrichs. That little lady now, I think that the unions would have lost in that one. That remains to be seen, certainly with Fisher. So on one hand, the court would have been considerably contentious. On the other hand, people are saying now that it's only 8 under Robert's leadership, and I put leadership in quotes there, frankly, the court is having to come up with some kind of compromises, is trying to reach some kind of consensus moving forward. But regardless of whether Garland will be approved, it's certainly not this term, reality is we're doing with 8 members of the court, and I think it's thrown a bit of a fly in the ointment in some of these key cases that I think will eventually come back to us in other ways. In Zubik v. Burwell, Burwell is the Secretary of Health and Human Services. Zubik is actually, for those who are not aware, the Roman Catholic Bishop of the Roman Catholic Diocese of Pittsburgh, Pennsylvania. He and a variety of other plaintiffs sued the government over the Affordable Care Act. And a couple of minutes ago, Teresa mentioned the First Amendment, but just to remind everybody, the 16 words of the First Amendment read, Congress shall make no law regarding the establishment of religion or prohibiting the free exercise thereof. I'm sure we've all studied and written and talked about what that all means, but I think there's a conflict there. The government can't interfere, and we can believe until we begin to violate the law. And so the Affordable Health Care Act came down. This is not the first, and I don't think it's going to be the last case on it. A year ago in Burwell versus Hobby Lobby, the Supreme Court granted that a private, non-religious employer, based on a conscience exception, did not have to comply with all the provisions of the Affordable Health Care Act. Under its own provisions, something like 1 in 3 Americans, something like 100 million people, are exempt from coverage under the Affordable Health Care Act, including Exxon, Visa, Coca-Cola, and the United States military plan. The plan excludes religious organizations such as churches, synagogues, and mosques, but it did not do for groups like such as Little Sisters, who are a group of Roman Catholic nuns whose ministry is basically to minister to indigent elderly people as they die. They would not have satisfied the requirement of being a religious organization under the Health Care Act provisions. On the day after the decision came out, I'm sorry to shuffle this in paper here, President Obama agreed with the decision. He said he believes that now women can still be served, but without burdening the religious freedom of religious groups. The Catholic groups in particular, since John mentioned Roman Catholic, in the interest of telling the truth or full disclosure, I'm also practicing Roman Catholic, have a divinity degree as well, so I do a great deal on church state. But they oppose birth control. And some of the birth control pills were abortifacients that would bring about abortion. So there's a real tough question there. Can the government require a religious organization to pay for medical coverage that is available elsewhere? Which the government has agreed is the case in the request for additional argumentation in the case, and still preserve religious freedom. A few years ago, some of you may recall the case of Hosanna Tabor. Hosanna Tabor had nothing to do with birth control, but the question was essentially who decides what a religion believes, who decides what a religious leader is, and a unanimous Supreme Court overruled the decision of the EEOC that the Lutheran Synod of the Missouri Christian Church had the right to decide who a minister is. So they deferred to the religion to decide who its ministers are, what its teachings are, and I think we see that as a little bit of what's happening here. I just wonder, though, and with Janet's lead question, if this is almost now not much ado about not very much, because both sides seem to have agreed, and although I mourned Scalia's death as a member of the court, whether you like him or not, it's hard not to mourn somebody's passing. Had he been alive, I think we would have had a much more contentious decision Now I think we're going to be looking forward to basically some kind of consent decree, but I still think that issues of religious freedom are going to continue to pop up, whether it's with the transgender issues or others. The one thing that's good about religion as a topic, it just keeps coming at you.
Got plenty to write about. And John, what about Fisher, the Fisher case?
So the Fisher case is, as you may recall, the case involving the University of Texas and their consideration of race in their admissions policy. And that case is now on its way up to the Supreme Court for the second time. And as Charlie said, it's an 8-justice court, which is very unusual. The court hearing the case the second time is very unusual. For me, one thing about the 8-justice courts, to me, the thing that's interesting about it being an 8-justice court now, several months after Justice Scalia's passing, is not that a Supreme Court justice died. Fortunately, that happens in the course of nature. The thing that's remarkable to me is the obstructionism in the Senate, where there has been a nominee to the Supreme Court for months. I think it's July 19th, I heard the other day, on July 19th, it'll be the longest that any Supreme Court nominee in history has waited for a hearing. And the Senate refusing to hold the hearing is completely unprecedented. And so the fact that the court is facing not only the end of this term with many controversial decisions, but next term is really a result of sort of unprecedented obstructionism in the Senate. And that's particularly key in Fisher, because in Fisher, there's no chance of a 4-4 decision because Justice Kagan cannot participate. She's recused from the case because she worked on the case when she was part of the Solicitor General's office. And so you have 7 justices, and so there's a real chance that you have a 4-justice majority of 7 ruling in Fisher. Because Justice Kennedy wrote controlling opinion the first time around and told the Fifth Circuit that they didn't apply strict scrutiny properly, that the policy in question is not narrowly tailored. So it's a very interesting situation for Fisher to be heard again. So what are the possible outcomes of Fisher? And what are the implications for schools? I think there are 3. From my point of view, the best possible outcome that you're going to get from Justice Kennedy as the controlling vote is to say to the Fifth Circuit, look, I've sent this back to you to look at it again, and you can't really look at it again without any additional evidence. The Fifth Circuit basically just looked at the issues again, wrote another opinion saying almost the same thing as said the first time, and then sent it back to the Supreme Court. And I think Justice Kennedy is probably troubled. And one thing he could do is say, look, what I meant is you need to send this back to the district court, and there are evidentiary issues on narrow tailoring that you need to get to. And I think that, given the posture of the court, would be a pretty good result. More thoughtful to consider issues of this, that allow for some Supreme Court justice to get nominated probably after the next president is elected, and the issue may come back again. The next worst outcome, I think, is for the Supreme Court to just say, no, this admission policy isn't narrowly tailored enough, and make the standard for narrow tailoring even harder to meet. And what that would do, create a little bit of a deterrent, a little bit more of a deterrent for colleges and universities and school districts to use race-conscious policies and procedures. I think the worst thing that could happen, which I think is the least likely in some ways, but could happen, is for the court to essentially say that the time for any sort of race-conscious public policy to promote diversity is over, that consideration of race in this way is not really a compelling interest anymore, and essentially overrule the Grutter and Gratz compromise position that Justice O'Connor came up with, and also probably could conceivably overrule Justice Kennedy's controlling opinion in the Hicks decision. And so, there's a possibility that there could be fairly dramatic changes out of Fisher. I don't think that's likely. I think one of the first 2 outcomes is more likely, particularly because I think, as Charlie said, with Justice Roberts' leadership and the court being cognizant of not being a full court, I think even the conservatives on the court who might want to go that direction may be hesitant to do so with a limited number of justices on the court, particularly Justice Roberts, who's expressed a lot of concerns about the integrity of the institution. I think it's a little unlikely that he would join a really dramatic, far-reaching opinion in this case. And so the most likely outcome, I think, is one or another version, sort of incremental changes to the standards that would apply to any race-conscious policy.
Do you think we'll see Fisher 3 then?
I think there's a chance that we could see Fisher 3.
Can I ask a Supreme Court question?
Okay, so how long can it stay for a court? I mean, how long can there be a on it? Is there some point at which, because I understand everything, and maybe I need to take another government course from senior year in high school, but I do recognize that, okay, President Obama has presented someone, and there hasn't been a hearing, and this poor guy's been waiting, and the Senate basically said, no, we're not going to do it, and they want to see who the next president is. The Senate don't like the next president, and the Senate remains kind of the way it is, where they have the power to still say that. Could we wait longer? I mean, how is there a point where somebody can say, you know what, y'all just got to make this happen?
So that's a great
Isn't
question.
there a mom somewhere saying, look, think of you guys, let's go up there in that room and figure it out. Don't come back down here until you have the answer now.
That's a great question. The funny thing is there is not in the Constitution any identified number of Supreme Court justices. And so in the past, the Senate and the President have at various times changed the numbers of justices going way back in history. Probably knows the history better than I do. But it's been all different numbers over time. The thing that's unprecedented here, though, is that the Senate hasn't said, we're going to make this an 8-justice court, we're going to take action, we're going to take a stand and make it. They're kind of playing a political game and saying, oh, we're not going to confirm this guy, without saying, we're going to change the number of justices. They really are waiting, I think, for the next president. And it seems like the intention is to probably hear a nominee regardless of who the next president is. That's sort of how I read between the lines. But I think that's very problematic, constitutionally speaking, because they haven't taken action changing the court, and there's no suggestion that the nominee is constitutionally appropriate for the court to, or for the Senate to fulfill their function of advising the president and consenting or not.
And just as a reminder, if you remember from American history, Franklin Roosevelt wanted to increase the number of justices on the court because he wasn't satisfied with the way they decided. He said, maybe next time. So there is no magic number. And I go back to the early years to 5 members on the court, and it's seriatim. Checks in the mail.
Well, Charlie, I have another question for you surrounding union fair share agreements. In March, the U.S. Supreme Court held in Friedrichs versus California Teachers Association that unions could assign fair share fees. Could you describe this decision and its implications for school leaders?
Sure. Let me start with the implication. I think business is going to kind of go on as usual for a while. I don't think there's any significant change. But this case comes in the midst, or at the end, or in the context of about 40 years of litigation, beginning with the case from Detroit in the 70s, about whether unions can collect fair share fees. The notion, and it strikes me as fair, and let me say, I don't have a dog in the fight. My dissertation was on unions and Roman Catholic education. That's almost a fiction in reality. So I'm not particularly pro-union, I'm not particularly anti-union, but fair share fees say that even if you're not a member, you must pay a percentage of the union fee because you benefit by the raises and benefits and what have you that a union represents or achieves for you. And never having been a union member, that strikes me as fair. I don't have an issue with that. But let me read some statistics at you. The most recent report I could find from the U.S. Bureau of Labor Statistics, January 23rd, 2015. In 2014, the national rate of union membership was 11.1% across the country. In the private sector, that's an all-time low of 6.6%. And in public sector, which includes education, of course, is an all-time high of 35.7%. So much of this litigation is coming out of public education. The case itself originated in California by a group of teachers, some of whom were affiliated with a Christian organization, said, we don't even want to pay fair share fees because we're not entirely satisfied at the accounting we get of how our money is being spent, and some of the money is in fact being spent on political causes with which we disagree. And again, I've got some footnotes in here if somebody wants, I can send you the article. But the data are pretty clear, and again, I speak softly and lightly when I bring up political issues, but just about all the data indicate that union donations run at least 10 to 1 in favor of Democrats over Republicans. And so people don't want their money supporting points of views, whatever they may be, with which they disagree. The courts in California basically relied on a Booth, the case from Detroit, which said fair share fees are fine. If you read the tea leaves of oral arguments, and I have some of that discussion in here, it seemed pretty clear that Scalia had a 5-judge majority that would have invalidated a Booth. It was a non-school case 2 years ago where they came right up to the doorstep, but then backed away, let the union fair share fees stay. And so I think for the next few years, unless or until there's another lawsuit, and depending on who's on the court, I think union fair shares will stay. I know that West Virginia recently became the 26th state after Michigan and Indiana to have right-to-work laws, which made union membership optional. There's some growth in that area, but key states such as New York and California will never adopt such legislation. So I think unions will continue to operate as they are in the public sector. And I begin the article by saying whether people like unions, or do not like unions, they've certainly done a great deal to advance the needs of teachers, and I like to think the needs of children as well. One last note that I found interesting, I had submitted this piece originally right after the court ruled, and then I found some more material on my rewrite for West. And I found this in the Washington Post, which I don't think is generally considered to be too conservative leaning of a newspaper, in all fairness. And they had a story here, Catherine Hull, why small business lobbyist fighting Merrick Garland, and this is a direct quote, this one's actually from the Cleveland Plain Dealer. Out of 16 important labor cases that came before him as a federal appellate judge, he ruled for the NLRB in all cases but one. And in that one that he didn't, he ruled in favor of the union. So at least on this immediate case, I think there's some concern with regard to labor that he's not quite as moderate as he says. And again, I'm not involved in that fight, just perhaps to give some reason why, but there are bigger issues going on than that. I think unions are here to stay like rock and roll is, and with that, I'll turn it back to you.
Thanks. Let's stick on federal level issues. So in December, Congress passed the Every Student Succeeds Act, or ESSA, and that replaced NCLB. Seamus, what is a provision in ESSA that a school leader may not know about that they should know about?
So I think ESSA is branded as almost like a dereg version of NCLB, like a pared down version. It's over 1,000 pages. And regulations are being developed right now through a unique process called negotiated rulemaking. So in terms of the substantive piece, probably one of the more interesting areas is, one of the more interesting areas is not substantive, it's more of the process as applied to Indiana. Because one of the things that happened in the last General Assembly session was the General Assembly set a sunset for ISTEP. ISTEP is no longer our standardized test in Indiana as of 2017. And it created a 25-person committee to study a variety of issues, one of them being what's going to be our future standardized test and what are we going to do about evaluations and some other very important topics. And they set a deadline for the recommendations from that committee of, I think, December 1st of this year, which would essentially be teed up for action in 2017 General Assembly session. However, coming back to ESSA, the regulations, which is a lot of where the details are, where it actually gets implemented, the deadline for those regs to become finalized is not until after the committee recommendations are due. I keep on thinking about that, and I realize that they'll have a heads up on what those regs are going to be, but they're actually not going to be finalized until after the recommendations from this committee, which is very much dependent on what the federal law says to do. So I have no idea how that's going to play. I can tell you that because of that, the 17 session is going to be quite interesting. In terms of like one specific area, because there's so much stuff in ESSA that I think people get surprised at when we kind of do a legislative debrief, is there's a lot of language about educating the communities about a family's opportunity to opt out of standardized tests. And it's kind of complicated what that actual language means, what the obligations are, whether it's benign, what's the actual teeth to it, but there are several provisions that require, under language like transparency, the school to educate their community about every standardized test that they do, whether it's mandated by the Fed, state, or where they decide to do it locally, and educating them about their obligation or their opportunity to opt out. Almost implying that they have a right to opt out, which is obviously, for those that have worked in schools and implemented standardized tests, realize that's become quite the issue. So that's one example of something that some people aren't aware of.
What do you think, John, when it comes to ESSA? How monumental of an accomplishment and what kind of dramatic changes will happen in public education?
Well, that's an interesting question, because I think it was a very monumental accomplishment in some ways, but I think the second part of your question is how many changes, I think is very uncertain. Why do I say that? Well, first, I think it was monumental because the Elementary and Secondary Education Act was 8 years late in being reauthorized, and we have a very divided government that legislatively has not accomplished a lot, and to their credit, Senators Lamar Alexander and Patty Murray got together and hammered out a bipartisan compromise that, because of all the criticism from various quarters on NCLB, passed. And it was sort of, for those old-fashioned people who see politics as the art of compromise, it was a classic example of that, where there was a lot of horse trading and behind-the-scenes work by their staff members to come up with something that actually, from my perspective, was not that bad compared to No Child Left Behind. Now, why do I say that it's not that bad? There are a few problems in it, a few drafting errors, and then a few things about it that are intentional. One of the drafting errors that I think you should be aware of is that I don't think Congress intended to reduce the amount of block grants to school districts, but it effectively has, because it has increased by 3 percentage points the amount that states can use for school improvement grants, which are competitive as opposed to the block grants, and it's also reduced by 3% the amount that states can require to use for direct services, which also doesn't go to school districts. So for those of you who are in public school districts, what you can do is advocate for an increase in authorization and make sure your representatives know that, because the overall loss in terms of block grants is about $900 million. And I don't think that was intended, but the problem is to compensate for that, they're not going to go back at this point and probably rewrite the law. So to compensate for that, the only way I think to address it is to push for higher level of authorization. So I think that's an important thing to be aware of. On the opt-out issue, I think being aware of the federal regulations, as Seamus says, is very important. The statute has that language in about educating people about opt-out. The draft regulations from the Department of Education are talking about requiring states to have some sort of punitive mechanism if you don't have 95% taking the test. So there's obviously a tension there that needs to get worked out. And then the thing that I think was intentional about the Every Student Succeeds Act, and that I think is really important for us in Indiana, is that it puts a lot of important issues back to the state. And under the waiver process and under No Child Left Behind, the federal government has basically forced states to put a lot of things into their state education laws and policies. And now those things can be revisited, but they will only be revisited if people push against inertia, maintaining the status quo. So if the states don't make important changes to what they've implemented under No Child Left Behind, even though ESSA was a monumental accomplishment, it might not make that much difference. And so it's kind of on us at the state level to really get involved and to really push for the kind of education reforms that we need, because the field is more open now, generally speaking, on this stuff.
Very interesting. Well, we have a lot more to talk about, but we have run out of time, unfortunately. I do know that the presenters will be around for the next 15 minutes. We'd like to ask them questions, as well as throughout the conference day, we'll have conversations. I do want to tell you that we're going to take a 15-minute break, and there's restrooms out that way. Grab more food, and we will return at 11 o'clock. Please join me in seeing this wonderful panel.
Is this your first function in your new job? Taking 6 hours of college credit. I'm in the professional development plan, 90 hours in 5 years. I just like Dr. McCarthy. Casey and I introduced ourselves first. Yeah. You're talking at 4:15? Yes. Things I've never even thought of. I'm not sure I'll still be there. No disrespect. I told David that I was going to pass it on. But it was very cool. Face this issue. Here's how we're handling it. The assessment class, I could take the final exam today just based on the professional development. Realizing that more and more by looking at the finance
tell you what, I know they're driving a whole lot. Katie is coming, she's going to work at my office.